Hello everyone, welcome to Cashcroft TV. My name is Kaylin Ashcroft. Thanks for watching this video on Guide to Legal History and Historians, where we will be covering the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tollins. As with all the other videos, I mentioned I've asked for permission to make this video, and it seems like it's fine. However, I must tell you that I have not been vetted or endorsed by the editors or the Oxford University Press. So briefly, a little bit about the book, if this is your first episode watching, because they must not be watching in chronological order, for the book itself is not written in chronological order. Rather, it's more a compilation of many different writings or many different chapters by different legal historians or legal scholars. So for this video, we will be covering Bryan, Wagner, and Fleming, and their two respective chapters. So, and at the end, this is in the style of Plutarch's Lives, probably one of the most important academic influences in my mind. And what he did is, in his parallel lives, is he would compare two leaders, one from ancient Greece and one from ancient Rome, and then he would do a comparison at the end. Sometimes they would fit together quite well, and sometimes they wouldn't. Sometimes they'd be long comparisons, sometimes they'd be short comparisons, but nonetheless, I think the exercise of going through that comparison process helps solidify a lot of the ideas of the two individuals. So that I will be doing with these two individuals, not because these individuals were ever opposed to each other or because their content actually does oppose each other, but just because it fits that way, and they happen to be next to each other in terms of the order of the textbook. So, without further ado, we will begin with Bryan Wagner's chapter. So this chapter is in the section part 2, Conceptualizing Legal History, and his chapter is titled Historical Method in the Study of Law and Culture. So a little bit about the author of this chapter, Bryan Wagner. He is a professor in the English department at the University of California, Berkeley. His research focus is on African American expression in the content of slavery and its aftermath. His specific interests include legal history, vernacular culture, urban studies, and digital humanities. He has a PhD from the University of Virginia in English Language and Literature / Letters. His first book was titled Disturbing the Peace, Black Culture and the Police Power After Slavery, published by the Harvard University Press in 2009, and his second book, that covers a new theory of Black vernacular tradition based on its historical engagement with criminal law. And his second book, The Tar Baby, A Global History, published by Princeton University Press in 2017, covers the global tradition of the tar baby, which is folklore that existed in hundreds of forms and in at least 5 continents. Since then, he has written at least 3 more books in 2019 alone. One of them is called Looking for Law in All the Wrong Places, which is an essay collection edited with one of the previous legal historians I covered, Marianne Constable. So please watch that video as well. In his principal investigation projects in digital humanities, he's a principal investigator in projects in the digital humanities, including the Louisiana Slave Conspiracies Project and the Treme 1908 projects. He's currently writing a book called The People's Court, Law and Performance from Slavery to the Civil Rights Movement, which reconstructs the period-bound demotic tradition in music, folklore, popular theater, and vaudeville comedy based on the procedures and processes of the minor judiciary. So, very interesting stuff, so I encourage you to check out his previous works and that which is coming up as well. And I think there might be a lot of overlap in terms of that lattermost book with Simon Stern, so I also recommend you watch that video too that I previously created. So his chapter is in part 2, Approaches Conceptualizing Legal History, chapter 11, Historical Method and the Study of Law and Culture. So in this chapter, many of the chapters are subdivided into sections, but his work is all one big section, so I'll try to subdivide it as best as possible, however. He opens up with a statement: to research law and culture, or to research legal history as cultural history, to discover the law in culture or the culture in law, is always and inevitably to engage with the mythology of the state, a mythology that was best given its most comprehensive expression by Max Weber, who was a German sociologist, historian, jurist, and political economist living from 1864 to 1920. He's a theorist, and he's one of the major theorists in the development of modern society, which will make sense very soon. The earlier approaches before Max Weber, he said, treated law as an organic expression of national or universal culture. However, Weber consolidated the modernist paradigm that emphasized developmental tension between law and culture. So I think of it as some ways synergizing the two. The previous tension resulted in the gradual disembedding of the state from a cultural environment as conceived as a total ensemble of knowledge, principle, and practice. So there was a sort of division because law was already supposedly already all-encompassing, and there were two distinct fields, but Max Weber does combine them as we see. Building on the narrative of world history, it was furnished from previous generation of evolutionary anthropologists, including polymaths such as Henry Summer Maine and Edward Burnett Taylor, and they believed the political authority dispersed throughout the political culture was dispersed throughout political culture. Therefore, it was impossible to divorce law from traditional organizations based on kinship, religion, and ritual. Max Weber's politics as vocation covered modern societies, distinguished modern societies on the other hand, in that they were distinguished in fact that they evolved, the state institutions evolved to be autonomous from culture. So what is and they were therefore more rational and predictable, and they reached a point to claiming a monopoly on violence, and law was to produce, maintain, and enforce violence legitimately. So essentially in the further back past before, it was seen as though law and culture were combined. However, they sort of got separated as two distinct fields, and that there was culture on the one hand, which is represented by the people, and as in previous videos, a cultural approach would be a bottom-up approach looking at the people, or sociological approach as well, whereas law was distinct, separate from culture, in that, for example, the law had a monopoly on violence. For example, you could do in some jurisdictions they had the death penalty, which obviously no individual would have the right to kill someone. But this myth of modern government was influenced by the thinking of law and culture, based on two components, in that it was a framework for universal comparison of traditional societies, where law was embedded in culture in the traditional societies, and in modern societies, law was separated from culture. And furthermore, in terms of law and culture in modern society needed to be conceived in relationship, and therefore culture was at law's outer edge and therefore distinct as time went by into the modern territory. It says critical engagement with this relational scheme needs to extend back the decades into the late 19th century. So in current times, law and culture need to be connected once more. And they are, for example, in modern times, they are still influenced by old ideas. So he says this chapter explores some ways that legal historical research has been conditioned by the concept of law. So connecting them once more. Above all, he says, it argues the importance of understanding key terms of analysis in light of their intellectual history, and hopes that one perceives law and culture not as natural kinds, but as inherited ideas. So there was no great division of law and culture, but they are inherited ideas. So I make a little division here. So in the 20th century, social science began to lose its inclination to equate the differences in culture to differences in development. For example, in Crime and Custom in Savage Society, published in 1926 by Bernard Malinowski, it suggested primitive people actually had laws by looking at culture, not form. Another book he references is The Cheyenne Way, published in 1941, which was an interdisciplinary work by Carl Llewellyn, who was a law professor, as well as with his assistant, Edward Hobill, who was an anthropology grad student, and they took a case method and applied it to the society with no supposed legal traditions, that is the Cheyenne Society. So showing that culture and law were connected, even though it might not have been a doctrinal law or it might not have been written law. He says, it's hard to overstate the importance of these two books on legal history and legal anthropology. Particularly the latter recognize the tension between the formal rules and their practical expression. For example, Cheyenne people remained fully integrated, or a fully integrated culture, standing in context to self-division, in contrast to the self-division in modern society. So in modern society, where it's often perceived that law and culture are distinct, in the Cheyenne culture, they did have laws, and it was almost intelligible from the culture itself. But still, there's the caveats that even though these works were great in that and some of the best for their time, and that they truly did connect law and culture, they're still through a Western lens. For example, Michael Rolfe Trouillard, in the culture, says the culture concept is inextricable from colonialism, and Silencing the Past, Power, and the Production of History. That's what he says in that book. Another example it used is that Edward Taylor published the first general anthropology textbook in English in 1881, but at the time Barbados had already been settled by Britain for 2 centuries, and Cuba by the Spanish for 4 centuries, and Haiti was independent after already a century of colonialism by the French, under French rule. Therefore, he says, mongrel demographics and stable crop export economies are impossible to distinguish from the modern characteristic distortions. So although these books were very useful, they're still through a Western lens, and that they still perhaps might not go far back enough, because the older of the two, by Malinowski, was 1926, and that was long after there was a colonial influence. Therefore, culture is seen to present a heterogeneity to law's homogeneity. Doctrine is important, and strict method, for example, in Laila Abu Lughad's celebrated essay, Writing Against Culture, she wrote, ethnographics of the particular, and that there was a methodological imperative, which paradoxically insists that a strict application of culture concept but disavows culture in the name. So there's this concept that culture is a very contrasts law in that it is heterogeneous. Like there's no strict rules. You can look at it through different scopes, different groups. There's so many ways to look at it, whereas law is taking the doctrinal approach, very homogeneous. However, Leila Abu Lughad suggests this methodological imperative by using ethnographies of the particular. However, that's an alternative to culture, so paradoxically it doesn't even, it uses a different word for culture that would align better with law, but in Bryan Wagner's perspective, you could still say it is culture. And not only comparative research has a methodological challenge, but also studies that seek to understand the relationship between law and culture in modern society. In that it contrasts there's a contrast between the cohesive, primitive, and the internal division in modern society. That, for example, law's autonomy for procedural norm for uniform application of doctrine. So there seems to be from some people's perspective, but which Bryan Wagner tries to argue against, that the two are irreconcilable. Other times it's described as an unfortunate symptom of the inevitable chasm between legal doctrine and the dynamism of the social world. Both are discontinuous but continuous social domains. and there's a shadowy proximity that is best understood through the metaphors of power, influence, penetration, and mental and mutual determination. Researchers concerned with relations among the economic, political, and cultural domains of society, but the separation of law and culture is one of the hallmarks of modernization. So often, in previous chapters, and we'll even see, there's law in economics, law in politics, but law and culture seems to be something that's irreconcilable in that, and it might even be an achievement that they were separated. For example, giving law the monopoly of violence brought new security and predictability by elevating it beyond culture. And furthermore, culture can be subdivided into folk culture, mass culture, and alt culture, making it further heterogeneous. Culture is a humanist sense in that it's general body of arts, or, for example, or the cultural anthropologies of sense, and it's a whole way of life. But for this chapter, as continues, he says, we will not survey the relationship between law and each of these different types of culture, but will emphasize the historiographical problem revealed to all, and that's the problem of legitimacy, which is inherited from the classical tradition of political philosophy and particularly early modern discourse on natural law. So in the 20th century, legitimacy question was recast as into two ways. One, how culture encourages people to consent to be governed, and two, how culture interrupts tacit consent by providing an intuitive and immediate alternative to political identification with the state. So I drew a little division here. So going into these questions, so how can this be reconciled? It says, conventionally, the first step in determining the legitimacy of the law is how law is to break down ways imposed on the population. For example, discipline is imposed through churches, families, trade unions, schools, political parties, and communications media, and discipline is also imposed through military and the police. So, and the distinction between indoctrination by culture and indoctrination by threat. So that could be one perceived as the indoctrination by culture is culture, and by threat would be law. For example, the classics by Karl Marx, 18th Brumaire of Louis Bonaparte, it interprets the rise of French authoritarianism after 1848 revolution, and Antonio Gramsci's prison writings, which follow the Italian fascism after the defeat of the factory councils in around the 1920s and led to the rise of Mussolini. And these were, they thought, set precedents for policing the crisis. There's another work, which was an interdisciplinary work by Stuart Hall and by the Birmingham Center for Contemporary Cultural Studies, in that there was a government by consent, and would be the normal state, and the government by violence would be an alternative state. So he brings in this new idea that there's a spectrum of culture sort of shifting into law. So you start in this kind of, you could say maybe a more primitive society where it's run by culture and no laws at all, and then on the opposite side, a complete police state, as you can see in what Karl Marx presented. We saw with Louis Bonaparte, who was an emperor of France, and with Mussolini, as Antonio Gramsci predicts. And for example, it covers the street crime epidemic in the United Kingdom from 1972 to 1973, and illustrates the relationship between culture and law, and the distinction between consent and coercion, or hegemony, which would be rule by interdoctrination, and domination, rule by violence. So you have a hegemony, which would be seen as the cultural side, and you have a domination, which is seen as the legal side, or an authoritarian state. And since the 1970s, historians have become increasingly skeptical of this binary characterization of legal systems, however, and they've become more clear in looking for law as a unconventional non-government setting. So it's kind of being skeptical. Is it so binary? Is the law completely contrasting culture? And therefore they look for similarities between primitive and modern societies, or metropolitan and colonial societies, or state-based and culture-based societies. So by comparing the two, they see there's actually a lot more similarities, and even in some of the most authoritarian states, there's still cultural drives. Example, the informal norms and dispute resolution norms of the raft fishermen in called the Zanjera farmers. They invented new ways to govern themselves without the state-based legal processes. So just an example that there is laws outside of the written laws. In Robert Cover's Jurisgenesis, he uses a term that is legal meaning through cultural meaning, which he contrasts to jurispathetic, which would be legal meaning caused by the state or caused by coercion. And therefore you see a sort of legal pluralism, and where the first principle is that law comes from many places. So law can come from both culture and from the state, and even in the most authoritarian state. This is not analogous, but examples of policies based on religion, status, kinship, and obligation, for example, are sources of laws. And they're not coeval either, but co-substantial with secular and bureaucratic government institutions that are supposed to have superseded them. So it's not like law just comes after culture. They're co-substantial, and sometimes culture leads into law, but sometimes law leads into culture, so they both exist sort of mutually. Anthropologists investigating legal pluralism, in particular in colonial societies like Australia and the US, have emphasized native rule is not custom but law, and it persisted even under colonialism. But it's difficult to determine what counts as law, because not everything can be considered law. Some things have to be considered culture, and some things have to be considered law. So where is the line really drawn? His view is that this ambiguity, however, is caused from the concept of culture being diminished and even eliminated in the effort to level the field of legal analysis. For example, William Sewell says culture as domain of society and culture as a dimension of analysis. So, for example, by William Sewell, there is culture which is used in the plural. For example, Samoan culture or Filipino culture, and then there's the latter, which is as a dimension of analysis, which is perhaps too general. So by taking a more specific term for example, Samoan culture, you could contrast Samoan culture to the actual written laws and draw the lines there. But if you're trying to draw the lines between culture absolutely and law absolutely, it's too ambiguous. This is a useful distinction in legal history, not a name for something, but an aspect of analysis concerned with creation and circulation of meaning. For example, going back to the state's monopoly on violence, law and culture has a positive approach, and it can be a turning point in world history. Whereas, this monopoly on violence some see it as a good thing, that the state has completely adopted this violence, but people see it as a negative thing. Culture explicitly opposed to the grand narrative of political development. So whether you think it's a good idea that the state has a monopoly on violence or not, that's kind of up to you, but this still has to be reconciled. They're both not an extension of culture, but institutional organization of brute force. So it's thought to be completely separate from culture, because, for example, it could be, for example, particularly in authoritarian states. Weber's exposition and Gramsci's and Gramsci-Althusser and Hall's alternative proposal is that culture is a way to orient people to the state's capacity for violence. So maybe culture led them to give the state this power anyways, and that's why you might see populist authoritarian states. And culture is a way to win consent or stir dissent. and it inevitably outstrips the state's actual powers. So by saying that society brought them to that monopoly in the first place, then it's culture anyways to begin with. But it's profoundly difficult to determine where law ends and culture begins. So when is it an authoritarian state and when is it culture driven? But nonetheless, there's still a spectrum we can observe. Robert Peel, in the 19th century first modern referenced the 19th century first modern police departments in that they should have infinite force, and there were scenarios of political philosophy. Society emerges from chaos to state's monopoly on violence. So kind of think of a very primitive society, and then Robert Peel says, and then they moved into the 19th century and then put it in the state and get absolute order. But even today, and this is the key aspect of the chapter, is that the state will never arrive at this theoretical apogee of authority pitched since the beginning. So even if, let's say, law is completely contrasted to culture, and it's never possible for it to have an absolute monopoly on violence to begin with. So there's always still a place for culture. And law's reach always exceeds its grasp. For example, he references vigilantism from cinema, such as The Birth of a Nation, or even Batman. So, for example, even in Batman is seen justified as an aspect of culture because he's actually, no one's supposed to know who he is, but he's justified in violence and he is not the state. Bentham, and further reference from Bentham to Broken Windows, and there's Broken Windows commentary, have sought the same situations to explore the limit cases for legitimate violence. So there's no such thing as the absolute monopoly on violence anyways. And therefore personal violence sometimes is permissible and necessary, and this is often seen as a notion of heroism. So law and culture is not merely related or continuous. They are the same in working together to compose the virtual reality of state authority, and it's a constant effect. So the state may lean towards having more power or less power, culture more or less power, but culture determines how much power the state has. So it's not even perhaps even a spectrum. Culture is constantly a force upon the state. And therefore reject the false clarity of modern states constructed with primitive cultures that divide society, where laws were driven by culture and then shifted into the modern state where it's all culture is no longer important, right? Or those that divide society into parts in order to sort its functions. So therefore, closing it off with some quotes: if recent attempts to overcome the inherited opposition between law and culture have not been accomplished and may never achieve the promise of a united field theory, our work can continue nevertheless without such guarantees. So just kind of a positive aspect at the end, that there's always a room for this research, because even if they cannot be completely combined, there's always, and even if you believe there's a spectrum and maybe in authoritarian states there's less reason to study culture, which I think Bryan Wagner would disagree. I think culture still kind of determines how much state the power has. There's always still room for research. So, because there's never going to be that absolute anyways. So, that is the chapter by Bryan Wagner, Historical Method in the Study of Law and Culture. So, briefly to talk about the slide, and then we'll move on to Anne Fleming. So, in terms of the images first, in the top right, we have the symbol of University of California, Berkeley, where he is a professor currently. Below that, we have the University of Virginia, where he received his PhD. And below that, we have Harvard University Press, where his first book was published. And below that, we have the Princeton University Press, where his second book was published. In terms of his institution, University of California, Berkeley, his position, Professor of English. His research interests are legal history, vernacular culture, urban studies, digital humanities. Suggested readings: Disturbing the Peace, Black Culture, and the Police Power After Slavery, published by the Harvard University Press in 2009. And the Tar Baby, his second book, A Global History, published by the University Press in 2017. And The People's Court, Law and Performance from Slavery to the Civil Rights Movement, which he is currently writing, and I encourage you to read it, and I plan to do so myself. In terms of the quotes, and some of them I've already referenced, however, I'm not not sure if you're just listening to an audio. I'll repeat them once more, and some of them I have not spoken. To research law and culture, or to research legal history as cultural history, to discover the law in culture or the culture in law, is always and inevitably to engage with the mythology of the state, a mythology that was given its most comprehensive expression by Max Weber. It would be, next quote, it would be hard to overstate the impact that Crime and Custom in Savage Society, published in 1926, and The Cheyenne Way, published in 1941, had first on anthropology and subsequently on legal history. So it's just, I think it's important how much he appreciates, for example, Max Weber and these two books. And my point is not that culture and law are merely related or continuous. My point is that they are the same in working together to compose the virtual reality of state authority. An authority whose real effects in the world are inseparable from their meaning. Last quote, if recent attempts to overcome the inherited opposition between law and culture have not accomplished and may never achieve the promise of a unified field theory, our work can continue nevertheless without such guarantees. So even if it's not never fully unified, which it won't be, there's always room for work. So that is a chapter by Bryan Wagner. I hope you found it interesting, and I encourage you to read more about him. And we'll learn a little bit more about him in the comparison as well. So, to Anne Fleming. So, her chapter is called Legal History as Economic History, also in Part 2, Approaches Conceptualizing Legal History, and hers is Chapter 11. A little bit about the author. She is a former professor at Georgetown University Law Center. She was an honors graduate at Yale College, and then also honors graduate at Harvard Law School, and during her studies she worked at law school at the Children's Law Center of Massachusetts, the Public Defender's Service of Washington, D.C., as well as the Harvard Legal Aid Bureau. She clerked for the Honorable Miriam Goldman Cederbaum of the U.S. District Court of the Southern District of New York, as well as, after that, the Honorable Marjorie O. Rendell of the U.S. Court of Appeals Third Circuit. So very significant clerkship experience. And she was also, after that, a staff attorney at the Brooklyn South Legal Service. Then, after this, she received her PhD in history from the University of Pennsylvania. Then, following this, she went to Harvard Law School to work as a Klemenko Fellow and Lecturer in Law, starting in 2009. In 2014, she started working as a professor at Georgetown University Law Center, and where she published The Rise and Fall of Unconscionability as the Law of the Poor. She also published City Debtors, A Century of Fringe Finance, published by the Harvard University Press in 2018. And she was currently working on household borrowing and bankruptcy in Jim Crow America from 1920 to 1960. That's what the time period covered in the book. However, she was still revising it at the time of her death just recently on August 25th of 2020 from natural causes, an embolism, which is a blocked artery. So rest in peace, Anne Fleming. This is the first individual who has actually passed away from this Oxford Handbook of Legal History. So that's very unfortunate, and it was well before her time. So I wish her family and friends the best. And I hope that if she's up there in heaven, or even if not, that she still had a very important academic influence. So her chapter is Part 2, Approaches Locating Legal History. Here's Chapter 12, Legal History as Economic History. So it opens up by saying the author thanks Mary Gold and Patricia Jerijan for their helpful comments on earlier drafts of this chapter. Nice to see that she went through many iterations, which I don't think is uncommon for any great writer, but I heard that, for example, just recently John Stuart Mill would rewrite all of his works twice independently just to make it better. So, and also having a third person to look at them, I think is important. But I'm sure that's probably the case for many others, but it's nice that she noted it. So hers chapter is divided into separate sections, so starting with the introduction. So over the past century, legal history and economic history have developed as separate fields of scholarship. This reflects the understanding of as distinct objects that may be pulled apart and analyzed separately. Even assuming, however, that they are separable, it is undeniable that they interact. For example, laws govern economic actors, and these actors interpret, apply, and sometimes shape the law. In 4 centuries ago, historian Henry Schreiber described the studies of this interaction as the borderland between law and economic history. However, with the growth of legal history as distinct from law over the past half-century, this chapter discusses this new borderland between legal history and economic history. So not just law and economic history, legal history and economic history. Robert Gordon famously divided the approaches of legal history into those external and internal. In terms of the internal, it explains legal history through legal sources and focus on charting the progression of legal doctrine and development of legal ideas and institutions. For example, Marilyn Salmon's study of former colonial and state-level rules about women's property rights as a change over time as an internal analysis. However, she does put the caveat, she also had external components, such as the external events like the American Revolution, as they affected the laws as well. Roy Kreitner, who is previously covered in one of my videos, which I encourage you to watch, very exciting intellectual, Calculating Promises presents a narrative of legal doctrine changes grounded in case law and ideas of legal scholarship. So 2 examples of internal legal history analysis as defined by Robert Gordon. In terms of the external approaches, this engages more deeply with non-legal sources and asks questions about law's effect on society and vice versa, and society's effect on law. Legal history in this chapter falls into the external category. So she will focus on the interaction between law and economics, dimensions of society, and vice versa. Namely, a society's processes for production, sale, and consumption for goods and services, as well as welfare institutions designed to address risks and inequalities of processes. Robert Gordon, who previously defined internal and external factors, credited Willard Hurst from the University of Wisconsin with breaking out of the traditional internal approach in the 1950s and 1960s, where he essentially created the legal history of economic change. And this has been many times revisited and revised, but we can kind of mark Willard Hurst as the one who sort of took this external approach and applied it by looking at the external approaches. So, in terms of the chapter will be divided into 3 parts. The first part will map the state of the field over the past several decades, identifying 2 major questions that have guided much of scholarship on the border of legal and economic history. The second part will describe 2 theoretical frameworks available to legal historians for conceptualizing the relationship between law and economics. And the third part will argue for future works of history of political economy that should put aside measuring compact of law and history or vice versa, and instead measuring the impact of law on history or vice versa, and instead focus on the boundary between law and economics that has been constructed and maintained over time. So this will make a lot more sense. That's just a brief overview of the 3 sections. So starting with part 1, law's impact on economy and vice versa. So 2 questions run through much of the work in this field. The first question is whether law is autonomous from economic developments, and if so, how much so. For example, how much legal history can be explained by economic imperatives. In the 1970s, particularly the field of socio-legal history was in its infancy. There are historians like Lawrence Friedman and Morton Horowitz address the question with different conclusions. Friedman's conclusion was that law was not autonomous, but rather a mirror of society, whereas Horowitz said that there was greater independence, and that law was to be autonomous to the extent that ideas are autonomous, at least in the short run. However, he still emphasized the importance of economic interests prior to the Civil War in the transformations to American private interests. So once again, kind of similar to the is culture distinct from law, as discovered in the previous chapter by Bryan Wagner. This is economic history autonomous from law, and as we see, Friedman said it was no, it was merely a mirror, but Horowitz said it was more independent, but still evidence that there was a connection. These, particularly Horowitz's work, was influential in shaping the agenda in the field. For example, historian R.W. Kostel described law and industry as locked together in a powerful dialectical exchange in his work on the 19th century English railroads. So sort of expanding on Horowitz, who might have wanted to prove that it was independent, but he didn't want to prove, but he evidenced that there was a lot of independence. He sort of inspired others to put it on their agenda to actually evidence the more connection, for example, as shown by R.W. Kostel on the English railroads. Furthermore, another example given is Ron Harris was proposed a similarly pragmatic and dialectic and contextual approach in his work on the 18th and 19th century businesses, which were relatively autonomous in some contexts, however sometimes functionally responsive to changes in the economy. So sometimes law responded to the economy, once again evidencing a connection between economics and history. And Ron Harris also I previously covered in another video, so I encourage you to watch that one as well. This also provoked others, including Jeremy Adelman. His economic interests were socially constructed and shaped by legal institutions, or he said economic institutions were socially constructed and shaped by legal institutions and the ideas, and that state and the market formation. He wrote about the state and market formation of Argentina. So the economic institutions were influenced by the law. So once again, there's kind of a push and shove dynamic. That's the vice versa component. In terms of William Forbath, the legal language showed that the legal language affected workers in American labor unions' narrow understanding of their own interests. So down to the legal language affecting how these workers perceive themselves, and then and as well as their proper role in the industry. Victoria Saker-Woest, in her work on agricultural cooperatives and their recourse to law, said that law formed both a malleable tool and restraint upon its subjects. It's often it can be difficult to determine the influence when there are other variables, as Anne Fleming suggests, in play. For example, Robert Johnson's work on the radical middle class in Portland, Oregon, said that the economic vision was rooted in an older populist and Republican ideology. So although we might be able to prove there is a connection that the economic society is influencing the law, or laws are influencing the economic society, perhaps there's a third underlying variable, in this case influencing the economic mindset. And then going to the inverse, which has been touched on, however, touching on in more detail, that laws effect on the economy, and that legal historians have, by posing the question, implicitly critiqued economic and business historians who have ignored and focused on changes in technology and significant entrepreneurs. So just by posing this question, she says it evidences that a lot of economic historians have focused specifically on technological changes, or the leading entrepreneurs, which would be a form of hero worship, we could say. But this was a counterexample would be Richard John's Network Nation, which stressed the importance of the structural presence of the state in the development of the telegraph and telephone industries, which in some ways I think he proposes, or he does propose, that it in many ways helped the industry develop. And she says later, but he uses a good summarizing phrase that politics had always mattered, and by politics we can say that's synonymous with law in this case. Furthermore, in Sally Clark's trust and power. It shows the importance of law on safety and on the insurance and automotive industries. So perhaps if there wasn't law, and economics were allowed to run free, we might have very unsafe cars or a very differently operating insurance industry. In the Commonwealth studies in the 1940s and 1950s were among the earliest to emphasize the frequency of the state intervention on the early U.S. economy. So some of this work had started all the way back into the middle of the 1940s and the 1950s. And the law could be seen as the language of the state, she says. In terms of Dylan Penningroth's research on slavery and property, there's a system of property ownership which was scarcely registered in statute books but deeply woven into society. So some aspects of the economy were independent of the law, but they kind of worked alternatively to the law. But maybe these practices were, which isn't the case, but maybe they were provoked because of the law. But this was not the case. But nonetheless, there is also the counterexamples as well. And therefore, this leads to the question, what is law, and how do we separate law from what's not law to understand the relationship with one and the other? So do we only focus on written laws? And this was a common theme in the previous chapter as well. So this moves to part 2, after having posed that question, conjugations and theoretical frameworks. So Catherine Fisk's theories of causal regularities in law and society relations were elusive and unstable. They tended to break down under critique into indeterminacy marked by complexity and contingency. So the connection's been hard to draw. However, therefore, if law shapes economic actors of their own material interests, or if there are always multiple variables, as previously mentioned, at play, then law and economics, in addition to law and economics, the project of separating law from economics and tracking the impact of each other seems doomed. So if we can never get rid of these additional variables, or if they're inevitably connected, it'll be impossible to decipher their effect on each other if there's an irreconcilable, or if they cannot fully be divided, which sort of leads to her 2 alternative approaches. The first alternative approach is not to look at law and economics as 2 separate and distinct objects, but look at law as economics, or economics as law, as a singular phenomenon. So that reconciles the first part, or the first issue. So if you look at it as one thing, then that avoids that issue altogether. For example, Rita Berla drew from Foucault's governmentality to see as 2 modes, not separate domains, governing human bodies and populations. So see law as economics as one sort of thing driving together, after acknowledging that they do affect each other. Furthermore, referencing Christopher Tomlin, who is one of the editors of this textbook, his law as a way of studying capitalism and vice versa, and not as distinct objects. We'll discuss a bit more next. And then there is also Timothy Mitchell as evidences the second approach to reconciling this issue, and treat law and economy as a false distinction, or as there's a false distinction based on the 20th state versus economy. So kind of going back to the state versus culture, there was a false distinction between state and economy, and these are arbitrary lines drawn, and therefore Timothy Mitchell suggests, and Fleming suggests, to have an exploration grounded in a particular time and place, and not a high-level theoretical generality. So by focusing on a specific time, you might be able to divide economics and history, or you might just be able to elucidate better findings as well. So that leads to the third part, future directions, kind of alluded to. So she says legal historians should heed to Mitchell's call for focusing on the specific and technical, and for example, among capitalism, so focusing specifically on law and economics interaction within capitalism. By focusing on a specific category, it'll not be doomed. And therefore, start with primary sources, not with theory about relationship and seeking to validate. So start with the primary sources. Don't seek to find a final answer and then pick out your sources to prove it, but rather start with primary sources and build up from there. And then you might ask how the boundary has been constructed over time. And therefore look into abstract labels like capitalism, as mentioned, and already, for example, within capitalism, there's already a tendency to do this. For example, they've just been a disaggregation. For example, there's the study of war capitalism as distinct from corporate capitalism. So looking at law as economic history at capitalism would be the most best way of doing this, rather than trying to see where does law affect economics and where does history affect law. But if we zone in on specifically capitalism, we can find a lot of more important findings, as shown in Christopher Tolman's work, who we'll be covering soon. And therefore look into abstract labels like capitalism, and therefore, yes, and looking at Tolman's work, capitalism is knowledge only through operations of the law. So, and Tolman's advocates very strongly for using the law to look at capitalism. And therefore, one must look where law also seems to be absent. And she says this might seem like looking for old wine in a new bottle, but this does not assume the separation of law and economics, and rather it's unexpected, and it may change as well, change the perceived boundaries. So looking at where there isn't law, you might find significant findings as well. For example, maybe the economics cause there not to be a law, but that is important in their interaction. And there, another example is, for example, the history of money. For example, Christian Dezen, the myth that money emerges from an exchange rather than legal engineering. So a connection between law and economics as through a specific lens, looking at money. And furthermore, Rebecca Sprang in her where she denaturalize and estrange money, thereby restoring its history. So by looking at it specifically, we can also take a better historical lens than trying to look at the entire history of law and economics, because it's too complicated and, as evidenced, perhaps doomed if we take too broad of an approach. And also, as mentioned, if you take a top-up approach, like for example, there is no connection, and then try to pick your examples, well, that's just not good. It's not a good scientific method. But it's most important to clearly identify the questions, and also these can be present as guides for policy making if they are done in this way, and therefore, and by breaking down the problem specifically, and not to have a presentist approach, but to use past answers from the past to unsettle present day thinking. And these answers will matter to those working at the border of legal history and economic history. So, if you're interested in this area of research, which I think is absolutely fascinating, which you should be, I hope you are, and if I didn't convince you, well, perhaps maybe read more of her work, and you will be. But as importantly, they may matter to those who are not as well. So, maybe even if you aren't fascinated, they might be important as well to understand, for example, capitalism or understanding money. It's important to understand the interaction of both law and economics. So that is the chapter by Anne Fleming. To talk about the slide, starting with the images, as always, in the top left we have the symbol of Georgetown University Law Center, where she was a professor. To the right of that, we have, in the top right, we have the University of Pennsylvania, where she received her PhD in history. Below that, we have the two courts where she clerked. We have the United States Court of Appeals, 3rd Circuit, and previously where she clerked at the United District Court, the Southern District of New York. Below that, we have Harvard Law School, where she received her Juris Doctor. Below that, we have Yale College, where she received her undergraduate degree with honors. Her institution was the Georgetown University Law Center, but unfortunately she passed away just last year, almost a year ago, August 25th, 2020. or I guess almost 2 years ago, pardon me. And she was a professor of law. Her research interests: contract and commercial law, consumer finance, American legal history, and law and poverty. Suggested readings: City Debtors, A Century of Firing Finance by the Harvard University Press in 2018, and Household Borrowing and Bankruptcy in Jim Crow America between 1920 and 1960, which was a work in progress until she unfortunately passed away. And that is City Debtors, a century of fringe finance. Pardon me, there should be an E at the end. There. Also, but still published by the Harvard University Press in 2018. Now to the quotes, some of which have already been covered. Over the past century, legal history and economic history developed as separate fields of scholarship. Yet, even assuming that law and economy are separable, it is undeniable that they interact. Second quote, legal historians should heed Timothy Mitchell's call for focusing on the specific and technical, cracking open systems that might otherwise be unexplored. Next quote, what will best advance the field is research that clearly identifies the questions it seeks to answer and explains why the answers to those questions matter. And last quote, the answers will matter to those working in the borderland between legal and economic history. As importantly, they may also matter to those who are not. So, a very important form of scholarship. So, moving to the comparison, so a little bit more on both of them. So, in terms of Bryan Wagner and Anne Fleming, so Bryan Wagner's PhD was in English from the University of Virginia, where the Anne Fleming's PhD was in history from the University of Pennsylvania. So, Virginia and Pennsylvania are not too far geographically, but they were in completely different fields, and but they're both quite old institutions, however. But it must be noted, however, Bryan Wagner does not have a law degree, whereas Anne Fleming went to Harvard Law School, and she had a lot of clerkships as well, and she did practice as a lawyer as well, or take many law jobs. They're both writers, they both produced books, and Fleming, they're both working on a book. Bryan Wagner is currently working on a book. Unfortunately, Anne Fleming didn't finish her or she was just revising her last book when she unfortunately passed away, but nonetheless both writers. They're both one tries to connect law with culture, whereas the other tries to connect law with economics. But they both parse through much historical information, and they both sort of picked out they very well elucidated what were the most important writings for their form of scholarship. So, kind of like a Cole's notes of what to read. For example, Bryan Wagner advocated, for example, Max Weber, and Anne Fleming advocated for the works such as Timothy Mitchell or Christopher Tolman. So, despite the plethora of information, makes it easy for someone like me to know where to start, to follow these two paths. And yeah, that is the comparison to both great intellectuals, and I hope you research them more, and I hope you continue to support them. Thank you so much.